We will start when we have 6. We normally end up starting about 12:10 each time, and the folks who are here right now are normally the folks who are here right at noon each time. So it's in a new year, and not much has changed.
Oh, really?
So that was recording right now, so.
Should I just get from the back? Like, I don't go all the way up there. Yep.
That's the worst. Like, just like I don't like since you
They all doing that?
No, just those two.
Ooh.
Can't things.
Ooh. No. These are all. Why he was called? Ooh.
We have a committee member who is between Hope Summit and here. we are going to wait to start until she gets here. And so that's going to be about 10 minutes. Just so everyone is aware, you can stand at ease, continue to stand at ease, but don't hold your breath because it's going to be about 10 minutes.
Yeah, that's my Friday. No, no.
That's what I was working on. I feel like they're all trolling me. That's what I'm gonna say. It's so gross.
It'd be really awesome if we developed a partner at least. Virginia Young's here. She lives here.
Not immediately.
That's the plan. Oh no, I was just around. Getting a bunch of my political friends to be like, hey, just tune into my Twitter around 12:15. If you just retweet a bunch of shit, that'd be great.
Yeah, what?
If we pull up our website now, there's Ryan Gosling right there.
I'm so sorry. And I'll be dancing checks this week, so that was. Oh my goodness, thank you. That what? Yeah, with this thing on it too.
House Committee on Government Oversight and Accountability will come to order. Mr. Secretary, please call the roll.
Representative Barnes.
Here.
Hurst. Here. Cornejo. Curtis. Fitzpatrick. Barr. Hubbard. Messenger. Here. Vescovo. Vinton.
Hey, yeah.
One day bipartisan forum. We will start the committee's notice here, and we're moving quickly. However, we're not going to move so fast as to make mistakes or overly complicate things. I noticed up 7 bills. I noticed some issues with 3 of them. Those bills are House Bill 1574 relating to the winding down of a committee, House Bill 1981 relating to a gift ban, House Bill 1998, which is my own bill regarding a ban on what I call exotic investments. This committee is unique in the House of Representatives because it does not have the capability to do a committee substitute. So anytime we amend a bill in this committee, what happens is the bill goes to the floor, and the first thing that has to happen is that there's a vote on the committee amendment. And so if any other member wants to amend this bill, if we've done a committee amendment, when the bill gets to the floor, that member who's not a part of this committee has to draft 2 amendments. One, assuming that the committee amendment is adopted, and a second, assuming the committee amendment is not adopted. The other thing we've learned from last year is that when we go to the floor with a bill from this committee that has committee amendments, there is mass confusion. And so I thought rather than on these important bills, rather than risking confusion and having staff have to draft 2 versions of every amendment, that instead we would hit the pause button on those 3 bills, have them refiled, and hear them next week. So that leaves us with 4 bills today. 1452 sponsored by Representative Hoskins, which relates to a biannual PFD filing. 1979 filed by Representative Rowden, which revolves around the revolving door. House Bill 1983 is Representative Dogan, and thank you, House Bill 1575, which I missed, which is PFD disclosure within 30 days. So with that, Representative Hoskins, you have the floor.
Thank you, Mr. Chairman, members of the committee. I'm Representative Denny Hoskins, represent the 54th District. Probably have what I would consider the least controversial of all the ethics bills maybe that have been filed so far this year. Here present House Bill 1452 dealing with personal financial disclosure reports. Basically, currently we have to, for any activities that are required to be on a PFD from January 1st, 2015 through December 31st, 2015 are required to be reported by May 1st of 2016. All my bill does is it says that any activity from January 1st through June 30th of each year would be required to be reported on July 15th of that same year. And then any activity between July 1st and December 31st of that year would be required to be reported on a PFD disclosure on January 15th of the following year. I think this, as far as openness and transparency, I think this is a better way to do that. I also, the May 1st deadline with our current PFD disclosure does not coincide with any other report requirements or disclosure requirements. And so what I've tried to do is implement those 2 dates in with the campaign finance disclosure or campaign finance reports that we have to file. And the fiscal note is 0. I'd be glad to answer any questions.
Questions of the sponsor, Representative. Proceed.
Was it, I know that something like this, or maybe this very bill was filed last year. Was that yours also, Representative?
Yes, that was my bill, and it may have been included in some other omnibus bills as
Okay.
well.
And if I remember correctly, and I don't know if you can answer this for me or not, but I believe that Mr. Clark from the Ethics Commission told me that these forms are basically online, so that if there's been no change between those time periods, that it's a fairly easy fix. Is that your understanding as well?
Yes, that's my understanding as well.
Thank you, Mr. Speaker, Mr. Chair.
Further questions of the sponsor? Seeing none, witnesses and to testify in support of House Bill 1574. Is there anyone here to testify against House Bill 1574? Is there anyone here to testify for informational purposes regarding House Bill 1574? Seeing none, Representative Hoskins, would you like to make any closing remarks in support of this legislation?
No, I think it pretty much summed it up. Thank you, Mr. Chairman.
Thank you. That was House Bill 1452. Right, I guess right. Committee's not like riding a bicycle. 1452. That will close the hearing on House Bill 1452. The next bill is Representative Bowden. I saw him in the hallway. It's not hazing. He only has one. You have two.
Sir, your pleasure.
Good afternoon. It's your turn, Representative. We will now open the hearing on House Bill 1983.
Thank you, Mr. Chairman. Good afternoon. HB 1983 prohibits legislators or statewide elected officials from serving as paid political consultants. Although many of us might be great political consultants, that would obviously be a big conflict of interest. And so I think this is a great step towards clearing up some of the possible ethical dilemmas that we can face as members here or statewide elected officials for that matter. And I'm open to questions.
Question to the sponsor, Representative Mitten.
Thank you.
Proceed.
So,
What is the cooling off period? Could you tell us a little bit about?
This isn't a cooling off period.
Oh, wait a minute, why is this?
Paid political consultants.
And this says what, that you cannot be a member at the same time that you're a paid political consultant?
Correct.
And it only applies to members, correct?
Members and statewide electeds.
And statewide elections, okay. I guess my question is why is it limited to those folks? Why wouldn't staff be included?
That's a good question. They don't have the same power as a member or as a statewide elected official, obviously. So they wouldn't have the same type of leverage over legislative actions.
Okay, but I mean, again, so I'm going to use my caucus as an example, just because it's easier. But say, for instance, a staff member in my minority leader's office is also a paid political consultant that I don't use for my campaign. Do you not think that having that person be a paid political consultant would not impact my ability to interact with my caucus leader?
It certainly could, but I'm not quite as worried about that as I am with members, and we've had past instances of this actually happening. When someone has the authority to determine which bills get passed and are shot down in committee, you just don't have that kind of authority as a staffer.
Okay, so the purpose, and again, don't get me wrong, I'm not saying that it's a bad idea necessarily. I guess what I'm trying to understand is, it seems to me that there are also staffers in this building that wield, frankly, a whole lot of, a lot of power. And they are often the doorkeepers for members, particularly members that could be in leadership. And so that's where my concern lies, is that to the extent that, you know, that relationship exists between a staff member and his or her boss.
Yeah.
Why wouldn't, I mean, we've seen press has done, I think that, you know, there's been newspaper articles about this. It's not like I'm raising a new issue on that.
Sure. The other consideration is that obviously as a staffer, you as an employer could prohibit your staff from doing that, or perhaps the House or the Senate could have a policy without writing it into law prohibiting them from doing that. You don't necessarily need to make it a law.
And then I guess I come back to then why wouldn't we? I mean, or your law, and I guess that's what my concern is, that your bill doesn't even address that issue. And it seems to me that those two, that both a member as well as a staff member are intricately tied, to the extent that the power about which you speak for an elected member can often also extend to an elected member, staff member. And so that's what my concern is that the bill doesn't even raise the issue. It doesn't even address the fact that that's also there. Does it require that a staffer disclose? I mean, a staffer doesn't have to file a personal financial disclosure either. So there's nothing in law that requires that staff member's relationship as a paid political consultant to anyone's campaign to be, there's no transparency on that front. And so that's my question, is why are we ignoring that?
Well, as a member of this committee, you're certainly open to offer amendments, so.
Well, I appreciate it, but why are you ignoring it? I guess is maybe the better question. I don't want to, I mean, if you see it's a problem as well, why would you not want to include that? Because
Trying to keep it simple. Keep it as simple as possible to start with, but if people have other ideas, I'm certainly open to adding them.
okay, and you don't see an issue then also with a staff member collecting a salary from the taxpayers and also working as a paid political consultant? So in addition to the issues that we might have
They have to do that.
about power.
They have to do that on their own time, and we as their employers would have to, again, allow them to do that. Anybody can just prohibit their staffer from engaging in any outside activities if they wish.
Right, I understand that, but you don't think that that concern rises to the level of something that should be included in your
I'm not saying it's
legislation?
not a concern, but I'm saying there's plenty of avenues to stop that right now.
But it's not transparent. That's my point. Whether it's stopped or not, I mean, obviously stopping it would be the best, in my opinion, the best goal, but short of that, at least have some transparency. And I guess that's my concern, is that you're bringing a bill that specifically addresses paid political consulting. And my question, what I don't understand, honestly, is why you wouldn't also include staff members from being either precluded from doing this activity, or, I mean, ideally precluded, or at a minimum to be transparent about it.
Sure. I don't have any objection to that.
But you decided not to make it be part of your bill.
No.
Okay, thank you, Mr. Chair.
Further questions of the sponsor? Representative Dogan, what's the level of scrutiny that limitations on political activity is analyzed under in court? You know,
I do not.
It might be something called strict scrutiny. Do you think that a person's working for a political campaign is a type of behavior that might be protected by the Constitution?
It could be.
I think that it is protected by the Constitution, and we understand the distinction between an elected official whose conduct can be circumscribed more by a legislature than someone who is not an elected official. Do you agree with that?
That would make sense.
That there's a higher standard, that there are certain things we can prohibit of ourselves that goes further than what we can prohibit of others. Do you generally agree with that?
Yes, that's true.
Okay. Any further questions of the sponsor of the bill? Is there anyone here to testify in support of House Bill 1983?
Good afternoon, everyone. My name is Jeremy Kitty, Missouri Alliance for Freedom. I'm here to just on record that we are in support of 1983.
That was detailed testimony. Questions of this witness? Representative, proceed.
I assume you're present for my previous inquiry of the bill sponsor?
Yes.
What do you think of that, about the staff members?
To be honest, I haven't looked into it, and so I wouldn't know how to respond. We came with the knowledge that the bill was meant for members, and so when we reviewed it, that's how we reviewed it. And so if we were to include staffers, that's something that we would have to take a look at.
Thank you, Mr. Chair.
Further questions? Seeing none, thank you for your testimony today. Further witnesses in support of House Bill 1983? Seeing none, is there anyone here to testify in opposition to House Bill 1983? Seeing none, is there anyone here to testify for informational purposes? Seeing none, Representative Dogan, if you'd like to have some closing remarks.
I think this is a great bill. Hope you will support it. Thanks.
Thank you, Representative. That will close the hearing on House Bill 1983. Next, we will have Representative Rowden, House Bill 1979. Representative, were you alive in 1979?
No, Mr. Chairman, I wasn't. I was alive in '83. Thank you for embarrassing
We can go on that. Do you have two today?
I do.
Yeah. We'll go in the order you want.
Doesn't matter.
Let's start with 1575 because it's pretty simple.
Thank you, Mr. Chair. House Bill 1575 makes an addition to the requirements for reporting out-of-state travel paid for by a nonprofit with the introduction and what I believe to be probable passage of a lobbyist gift ban. Being able to take gifts from any entity outside the state will no longer be allowed, but we felt like leaving the door open for legislators to have the chance to attend educational conferences and events paid for by a nonprofit was still appropriate. But with House Bill 1575, we're tightening the requirements for those trips as far as reporting goes. Currently, they are reported on our PFDs, and we don't change that. But as Representative Hoskins alluded to, right now the PFD reporting happens once a year, and so in theory you could take a trip in January and not have that trip reported under a gift ban environment until much later. And so we say with this bill that any trip that happens, the PFD has to be filed within 30 days of the trip, and failing to do so would bring about a $10 a day fine until that report is filed. I think that we felt like creating a new mechanism to just allow another layer of transparency and timely accountability was a good thing. So with that, certainly be willing to answer your questions.
Questions for the sponsor? Representative Minton. My decision to wait was so good. Representative Minton. I say that in all seriousness, Representative. I am being serious. We need a hot committee up here with questions. So, and I knew you would be ready with questions. So, Representative Minton.
Happy to oblige, Mr. Chair. Thank you. First, frankly, my biggest question is it's technical, and I'm assuming that you would not have an issue with this, but I noticed in reading your bill that there are several areas that have not been amended to create gender neutrality. In other words, I guess I'm on page 5, section 105.485. So it's page 5, lines, 6, I guess is where the first one that I have, where it says, shall file the following information for himself, comma, his spouse. And if he does not know, and his spouse, so I guess my question is, are you willing to amend your bill to provide the gender neutrality that I would certainly think is important?
I think that would be appropriate.
Thank you. And one of the questions that I had while reading all of these bills together, so I gotta apologize to you beforehand, just because I know that you're not the sponsor of all of them, and some of them have been continued, for lack of a better term. But for instance, one of the bills that we already heard, which Representative Hoskins' bills about doing it twice a year, I guess one of my concerns or questions is sort of how do all of these pieces work together? So, in other words, say for instance, there were to be a bill passed that says that all out-of-state travel paid for by third parties is not allowed, or by lobbyists is not allowed, then your bill becomes sort of moot, doesn't it?
Well, if we pass a law that says out-of-state travel, well, if we pass a gift ban, which is another piece of kind of the package that you're talking about, if we don't pass a gift ban, then this becomes, no, I don't even think it becomes irrelevant, because right now, the current environment would say that if we take part in this travel, that it's reported on the PFD in a yearly manner. So whether or not we were to pass a gift ban, and frankly, whether or not we were to pass Representative Hostin's legislation, this still adds another layer of more timely accountability.
Okay. And then, you know, I have to ask this, we're talking about transparency for out-of-state travel, but we're not talking about sort of, I mean, your bill doesn't address some other, in my opinion, glaring issues, or none of your bills do, in that we're still allowed to have giant million-dollar campaign contributions from single donors.
Sure.
So I guess my question is, how come with the bills that you filed and were pending before this committee, at least before I got here, don't include that?
Yeah. Well, I've said, and I think I could speak with a little bit of confidence, given the conversations we've had with Speaker Richardson and Floor Leader Cheerboy throughout the process of crafting these bills, that in the House nothing's off the table. I would say that, you know, there are a number of principled arguments, as well as court findings and court rulings that would probably back up the position that we've taken currently. But I would certainly say that if we're going to go down that road, we should do it in a single subject, tightly worded, single bill, so that if there is pushback from what I assume would be both parties and from what I assume would be both sides of the building, that wouldn't keep us from passing equally as substantive ethics reform like the things that we are pushing in this committee today. I think it's also of relevance, and to note that, you know, you look back over the last few years since my time in elective office, I think Missourians have proven a number of times that big money doesn't necessarily mean victory in elections. I think you could give a couple of examples. In 2014, there were 4 of my Republican colleagues who had hundreds of thousands of dollars spent against them in a Republican primary. All of them outspent many times over. All of them were victorious. There was a representative in my own county who spent $500,000 of his own money in 2014 and lost. Our senior senator, Claire McCaskill, gave $1 million of her own money to the Missouri Democratic Party in 2014. And the result of that was a historic minority.
But that's not really the issue about the campaign contributions, is it? I mean, it's not about whether or not you win the campaigns. The issue is really about, and it's the same issue when we talk about lobbyist gifts. The issue is really about what, if any, influence these dollars have. We're not talking about banning lobbyist gifts because whether or not
Representative,
yes.
we're going to have one more question on this topic. It is not at all related to the topic of this bill.
Okay.
And so I gave some leeway. I'll continue to give a little bit of leeway, but we're not going to have a 30-minute discussion on the topic that's not included in the bill file today.
I understand. Thank you, Mr. Chair. In any event, that's not really the point. So I appreciate your comments, but it's not about whether or not you win a campaign, because my having a dinner with Ameren does not make me win or lose my campaign, and it doesn't influence my vote in the way that a contribution could. So thank you very much. Thank you, Mr. Chair.
Further questions of the sponsor? Seeing none, are there witnesses in support of this bill? Seeing none, is there anyone here to testify against this bill? Seeing none, is there anyone here to testify for informational purposes? Seeing none, Representative Robb.
Thank you, Mr. Chair.
And Representative Minton, I think you have a good point on gender neutrality, but I'd ask that amendments wait for the floor for the purposes of confusion issue. That will close the hearing on House Bill 1575. Representative Robb.
Thank you, Mr. Chair. House Bill 1979 implements a 1-year cooling off period for legislators, statewide officials, and any office requiring Senate confirmation before they have the ability to become a lobbyist. This will apply to anyone, according to the language, that's elected after January 1st of 2016. So what that means is that everyone that is currently holding office has the ability to make a decision whether or not they want to run for re-election in the next general election, and if this were to become law, be subject to this language, or to not run for re-election in their next general election, whether that be the November of 2016 elections, or in the case of the state auditor or half of the Senate in November of 2018. They would get to make the determination that they want to run for re-election, be subject to this language, or they do not want to run for re-election and be able to move immediately into the lobbying realm. I've had a little bit of pushback from folks, some of my colleagues on both sides of the aisle, about what this does to restrict a legislator's future employment opportunities. And I gave it a little bit of thought and just kind of wanted to proactively address it. I assume they come up either here or on the floor later this week. But just a couple of things to say to that. I would say one, as has been referenced a couple of times earlier, I think we need to hold ourselves to a higher standard. I think this package of ethics reforms that you're going to hear this week and next was designed in no small part to reassure the public that we as legislators take their trust and the responsibility that they've given to us, we take that seriously, and that we are willing to do anything that we can to break down barriers or distractions to good governance in Jefferson City. The second thing I would say is that this doesn't ban any of us from eventually becoming a lobbyist. It simply asks us to wait a year. Just a year to cool off, a year to reassure the public that their elected officials are serving them, their constituents, that they're looking at this opportunity and not more focused on potentially the next opportunity. Certainly no law that we can pass is going to keep all of us from making the best ethical or moral decision in every circumstance, and I'm fully aware of that. But I think that what we can do is pass legislation like this, like a gift ban and some other things, that one, functionally make our environment here better, and two, go a long way toward helping restore the public's view of our environment. And so I think doing both of those things together through this series of reforms, and certainly through the revolving door, is a good thing. With that, I'd be happy to take any questions.
Questions for the sponsor? Representative,
Do inquire.
proceed.
Thank you.
Okay, well, you're saying it's just a year, but it's really not a year, is it?
I believe it is.
Well, doesn't it say that it's just a session? That's not a year.
Well, the where you have the ability to have influence is during session.
I suspect that many of the lobbyists in this building would beg to differ that they have no influence during the interim from, roughly mid-May until the beginning of January.
But we're not passing legislation from mid-May to January.
Okay, but you're implying that lobbyists aren't working? Because I suspect that clients would also be very interested to hear about that, and they may want a refund or two.
Lobbyists work very, very hard.
Right, exactly, during the interim. So,
but they don't pass legislation.
So there's some, but you're talking about a year, and it's not really a year. It's 6 months. Let's be clear about that. If that's what we're talking about, let's talk about it.
Okay, so would you be in favor of it? Are you in favor of it currently?
Of what currently?
Of the current language.
In the bill?
Yeah.
I don't think it goes, no, actually, I'm not. I don't think it goes far enough for a number of reasons. First of all, you're talking about it being a year, and it's not really a year. And second of all, that was just my next question. But so yes, I would actually be fine if it's a calendar year. But I think that, again, you're using the term a year, and that's not what your bill says. Your bill says a session, and they're not the same. A session in 6 months. A year is 12. Last I checked. Even in 1979. I think it makes a difference to a lot of folks. But
So
again,
you wouldn't vote for it right now, but you would vote for it if we put it to a year.
I think that I think that calling it a year is a misrepresentation, and I just would like to clarify that. So I have another question though, which is frankly more important as far as I'm concerned, which is, why doesn't your bill distinguish between somebody that serves their entire term, fulfills their term, or is term limited at least due to term limits, as opposed to someone who gets elected and 2 weeks later resigns?
What kind of distinction would you propose?
Well, do you think that there's a difference to the constituents of those two different scenarios?
Without a doubt.
So I guess my question is, why would that same 6-month period apply in both circumstances? Shouldn't the person that leaves 2 weeks after they're elected
Well, let's be clear, it's not a 6-month period, it's a session. So regardless of
which is actually less than 6 months, so.
So regardless of if they serve out their term or if they get elected and then resign, they still can't be a lobbyist the next term.
For one session.
Correct.
For one session, and again, that's my question is, don't you think that
What kind of distinction would you,
don't you think that they should at a minimum not be able to lobby until that their clock should not start until at a minimum their term that they would have completed had they not resigned and left their constituents without any representation? Don't you think that at a minimum those folks should not be able to begin to lobby, or that the clock should not start to run until their term is over, whether they decide to leave early or not?
So that would be, so you're saying they resign and then so for them it would be a two session for us.
Or 4 session, I mean, you could be a senator. I would not be at all happy if my senator were to be elected in November and then in December resign. It could be up to 4 years. I mean, actually, I don't think that's true. I think that there might be something constitutionally that requires a special, I don't know actually when it comes to the Senate. I know that in the House, there's nothing that does require that special. It could be, and we've seen that already in a seat that was we just had a special this year for a seat that had been vacant.
Yeah, I will say this. I've had some conversations with a couple of Senate sponsors of similar language, and I believe one of theirs does what you propose. And I'm not saying blanketly I'm not saying I'm against what you're proposing. There were a number of things that we tried to do in this bill and a couple of other bills that we butted up against potentially some constitutional issues when we were dealing with research. So I'm not completely opposed to what you're saying, and ultimately we're going to pass something out of the House and the Senate. If they pass Senator Onder's legislation, that's what his revolving door does. So we're going to have to find some agreement when we go to conference.
Why wouldn't you want? But it's your bill. It's your sponsors. So I guess that come back to my original question is, why wouldn't your bill? I mean, again, on behalf of the residents of Missouri, I think that every resident in the state of Missouri should be able to have representation. And I think that anything we can do. Excuse me, sir. Can I please finish my question? I think that anything that we do to minimize the possibility of, or to certainly, and frankly, I'd say that it should be extremely punitive, that someone that engenders the trust of Missourians to become elected and basically creates a promise to those Missourians that they are going to serve the public good, to then withdraw or to resign before they're even sworn in is an outrage, in my opinion. It is disrespectful to the Missouri's residents. And for the life of me, I cannot understand why your legislation would choose not to address that.
So one, again, I'm not entirely opposed to it, but two, I would say that you don't draft legislation, in my mind, you don't draft legislation based on the exceptions. You draft legislation based on the rule.
Well, frankly, this is becoming a rule. We've just had a senator. This is no longer an exception.
Well, we've had dozens and dozens, I would assume, of legislators who have faithfully served out their term and then have become a lobbyist. And I can think of 2 that fall under your rule. So it is absolutely the exception and not the rule.
2 in the 3 years that you and I have been here.
Yeah, and I'm not sure there have been many before that.
Okay, but you still just apparently don't seem to think that they should be treated differently. Anyway, I have another question, which is why are we only applying this prospectively? I mean, it seems to me that your bill is saying, you know, yeah, we don't like this revolving door or anything, but it's not going to apply to us. I mean, if I were to choose to resign, tomorrow and become a lobbyist, there's nothing in this bill that requires me to have any cooling off period whatsoever, is there? If I don't run for re-election? So why shouldn't it apply to me just as it would apply to someone else that's going to run in 2016?
In the process of crafting legislation, I don't get to just yell and scream. We actually pass legislation. And so in the process of doing that, we determined, based on the conversations that we had with House members and with Senate members, House leadership, Senate leadership, that the best thing that we could do is forge a middle ground that said that everybody who came into elective office thinking that they were going to have the ability to leave elective office and become a lobbyist has the opportunity to make the decision in that term whether or not they want to continue to be an elected official and be subject to this language, or if they want to remove themselves from elective office and go down that road. That is middle of the road compromise legislation language that I believe still functionally does what we want it to do, because the reality is, again, you are speaking to exceptions. I'm certain that a vast majority, if not all, if this bill becomes law, people are still going to run for re-election and they're still going to be subject to this language. So to say that this doesn't apply to current people is a significant misunderstanding or mistruth of what we're trying to accomplish.
That's absolutely not true, because we have quite a few.
So you're saying
we have quite a few members that are here already that are term limited out, for which this would never apply.
Correct.
So again, and as far as you know, you're the one that used words like "we're very serious about this." You're the one that brought that kind of language into it. So respectfully, I would say that if you're really serious about it, it should apply to everybody. Frankly, if you're really serious about it, then it applies to everybody, not just to the newbies, and that everybody includes folks that are in here today and are going to be turned out. So I have another question, which is, there's several points, I believe several points in the bill. The first one would be on the very first page, the very first section, so line 5. It says, you know, if you vacate the office by resignation, expulsion, term limits, or otherwise. And I'm just kind of, when I first read this, I thought, well, what does "or otherwise" mean?
Is that a question?
Yeah. What does that mean?
I mean, I would say that it's in any way that you leave office. I mean, I'm not sure what the question is.
Well, I guess I thought that it was interesting language for a piece of legislation, and I was just curious what it was supposed to mean.
Legislative research felt it was necessary to put that in there.
Okay, and I want to say that there might be one more thing. Oh, that's it. Thank you very much. Thank you, Mr. Chair.
Okay, so Representative, let's actually get serious. First of all, is it a common practice regarding this word "otherwise" to have catch-all language in a bill, just in case when we draft something, we might not think of a scenario? Is it fairly common practice for us to put a catch-all provision in a bill? If you looked at the percentage of bills in which we're trying to provide a list, what would you say it's probably over 50% that we have a catch-all at the end?
It would probably be the rule, not the exception.
So, I mean, it might not be that interesting to actually have a catch-all at the end of a phrase. Second, I want to ask you about what I think Representative Minton identified as a problem in theory, but not in reality. How many principals do you think would engage a lawmaker to sign a contract where they don't start lobbying, they quit their job in the middle of a term or at the start of a term, and they don't actually start lobbying until 7 months later? How many, do you think that that's a likely business practice to occur, is to find a future, is to, the principals will start signing futures contracts with elected representatives?
Yeah, I would assume that.
And do you think that there are many representatives who, in the process of thinking about this, would go out and seek out futures contracts.
I would assume that.
Okay. Now I want to ask you about what Representative Minton was inflamed about not applying to us. Can we pass retroactive legislation
No.
in this General Assembly?
No.
Okay, and so there are every member of this General Assembly ran for office making under an existing set of laws and regulations, is that right?
Correct.
And we're changing the rules and laws and regulations regarding what a person in elected office can do immediately after holding elected office.
Correct.
And what Representative Minton wants to do is to pass a law which purports to apply a new regulation or rule retroactively. Would you agree with that?
Yeah.
And let me ask another question about that, because she might take umbrage with the fact that retroactive classification. She said she could quit in 2 weeks and go do this, and that this bill couldn't stop it. What's the typical effective date of legislation?
August 28th.
Okay, can we do anything in a bill that retroactively regulates the conduct of any Missourian, not just legislators, but any Missourian prior to the effective date of legislation?
No.
Okay, now I want to ask you, since we're getting serious again, revolving door bans, while enacted in many states, there's a very thin, would you agree with me that there is a thin constitutional rope to walk?
Yeah.
And why is that?
Well, and I think the reality that we are.
You want me to continue leading?
Oh, well, no, I mean, I can. I can answer
Yeah,
the
go
question.
ahead.
You can if you want.
The right to petition government is in the Constitution, right?
Yeah.
What amendment is that in? It's the First Amendment, correct? Okay, and are you aware there's at least one case that I know of out of Ohio where a federal court struck down a state revolving door ban? Are you aware of that
I think
case?
there's a couple.
Now, there's a distinction in that case between, we want to make sure to get this bill right. That case was about a lobbyist who was working pro bono. They found the right plaintiff to challenge it. They found a pro bono lobbyist. So you didn't have that element of payment involved in the case. To make it pretty simple, it was sort of the purest form of speech because it was without pay. Do you think it's important, knowing that federal courts have struck down revolving door bans, that we are very careful with the way we actually craft this bill?
Absolutely.
Or would you rather instead go as broad as possible so that we can politically posture ourselves as being as tough as possible, and yet know that as soon as someone challenges it, it's going to be thrown out?
Oh, well, I mean, frankly, one's pandering and one's policy.
Well, I don't. Okay. Are there further questions of this witness? Representative Hurst. Not the witness, I'm sorry, the sponsor. First.
I think it is important what you're doing, because the public needs to know that we're here to be transparent and accountable for what we do. But like the chair said, we have to be careful in how we word that, because we have a lot of people maybe sitting behind you that want to testify. And so if they want to lobby, which is for an individual organization to try to influence the decision of a public official, would mean if someone came off the street, in effect, whenever they give their testimony, are they not lobbying? Even though the compensation is not taken into effect. I don't want to make this so broad to where one of our constituents, our Missourians, comes in here and is afraid to sit in that seat beside you and speak their mind because of something they might get pulled into, and then have a legal affair that they have to deal with, because we have this broad law that sucks them in and will actually discourage them from doing that, versus trying to take care of what we are doing here so that they are protected, so that they can do that.
Yeah.
That's not what you're trying to do.
Yeah, I would agree, and I think it's important to note that you know, the chairman and speaker and the floor leader and some of us who are carrying this legislation, we've worked pretty diligently over the course of the last few months, because there is a very thin line between, in some of these cases, what's constitutional and what's not, what has the potential to, and frankly, all of this has the potential to be challenged in court. But yeah, you probably sacrifice maybe going further, maybe wanting to go further, and maybe personally wanting to do some more things, because ultimately you have to pass something that stands up to muster and can move into law and be functional going forward.
And I agree with that. So in the legislation we have today, there again, you've said it yourself, that we need to hold ourselves to a higher standard. And I think the public should expect that from us as well. But we also have to take that care so that they are protected as well from being drawn into what we do. So we can put regulations on ourselves to make sure we do what is right. We're not here to put regulations on other people whenever they try to do something that's right. So I appreciate your legislation. Thank you, Mr. Chair.
Further questions of the sponsor? Representative, I want to ask you another question. I'll make a suggestion. When we pass a law that says certain activity is now unlawful, do you think that might help to change the culture of this building in a way that tells principals, representatives considering challenging any such statute that passes, that they might do so, but they risk the moral approbation of that future legislature. In other words, right now, this is not illegal, and it is deemed, although it's frowned upon, it is not deemed completely, entirely unacceptable behavior, so that we tell members for whom this has happened, hey, look, I don't want to talk to you about this. But that if we pass a bill, we can potentially create a climate where it becomes truly unacceptable.
And I think that's the goal.
For the questions of the sponsors, seeing none, is there anyone here to testify in support of this fine piece of legislation?
Thank you again. My name is Jeremy. It's a Alliance for Freedom. Just want to come here and give our support for this bill. You all are public servants. You all have the public trust in your hands, their confidence, and we believe that using that influence to then switch over to lobbying, which could create a conflict of interest of some of your work while you're in the legislature, could lead to some issues, and we believe that it has. We believe that the representative's bill helps to clean some of that up. And so,
questions of this witness? Seeing none, thank you for your testimony here today. Further witnesses in support of House Bill 1979? Seeing none, is there anyone here to testify in opposition to House Bill 1979? Seeing none, is there anyone here to testify for informational purposes on House Bill 1979? Seeing none, Representative Rao.
Thank you, Mr. Chairman.
Rousing closed. Okay. I now move that we go into executive session. And I want to take these up in the order in which we consider them. There have been amendments distributed. I drafted these. I'm not going to offer any of them for the reasons we talked about with the confusion issue on the House floor. Now, I want to clarify to members of the committee, we're going to hear other bills this year, and I am not going to apply this no amendments ever to bills in this committee rule to every single bill. I'm applying it to this subset of bills. So lest anyone get confused that a month from now we're offering amendments on another bill. We're doing a little special thing here for these ethics bills because I think they're high profile. They are worthy of our attention. They are worthy of floor debate, and I think everyone's going to be paying attention, but I want to get away from that confusion on the House floor that we've seen in the past based on committee amendments. So the first bill, Jason, do I have a script? I don't need. Oh. All right. House Bill, I now move that House Bill 1455 be voted do pass. Discussion. This is Representative Hoskins' bill on biannual PFD disclosures. 1452 is the bill we're on right now. I also believe it was part of the large omnibus ethics bill we passed last year out of the House. Any discussion? Seeing none, Mr. Secretary, call the roll.
Representative Barnes.
Aye.
Hurst. Aye. Cornejo. Aye. Curtis. Patrick. R. Hubbard.
Aye.
Messenger. Aye. Benton.
Aye.
Discovo.
By your vote of 9 ayes and 0 noes, you have voted House Bill 1452 do pass. Next, I move that we vote do pass for House Bill 1983. This was the bill sponsored by Representative Dogan regarding legal consulting by elected representatives for statewide and other elected representatives and senators. Discussion on House Bill 1983. You'll note there is an amendment in here. I'm not going to offer. I will offer that on the floor. Seeing no further discussion, all those in favor of Mr. Secretary, call roll.
Representative Barnes.
Aye.
Hurst. Aye. Cornejo. Aye. Curtis. Aye. Fitzpatrick. R. Hubbard.
Aye.
Messenger. Aye. Benton.
Aye.
Discovo.
By your vote of 8, nothing, you voted do pass House Bill 1983. The next bill is House Bill 1575. I move that we vote House Bill 1575 do pass. This is Representative Rowden's bill on 30-day PFD disclosures. Discussion. Any discussion? Seeing none. Mr. Secretary, call the roll.
Representative Barnes.
Aye.
Hurst. Aye. Cornejo. Aye. Curtis. Aye. Fitzpatrick. R. Hubbard.
Aye.
Messenger. Aye. Benton.
Aye.
Discovo.
By your vote of 8 ayes and 0 noes, you have voted do pass House Bill 1575. Now move that House Bill 1979 be voted do pass. This is the revolving door issue. Discussion. Representative Minton, should we engage in a debate? No,
Thank you.
thank
I'm
you.
not
Okay.
entitled to a vote of the sponsor, so. I won't
Okay.
debate.
All those in favor, sorry, Mr. Secretary, call the roll.
Representative Barnes.
Aye.
Hurst. Aye. Cornejo. Curtis. Patrick. R. Hubbard.
No.
Messenger. Aye. Benton.
Aye.
Discovo. Curtis.
By your vote of 7 to 1, you have voted do pass House Bill 1979. I now move that we exit from executive session. The other bills that were on the calendar for today will be refiled in some form. It's my intent to hear them next week, along with potentially other bills that we might have already been referred or might get referred. And we are swimming along. Any further questions of the committee? Seeing none, that will conclude today's hearing of the House Committee on Government